Sprunger issues, and number three, the default judgment that was taken for my non-appearance and Mr. Patterson's non-appearance at a November 16, 2016 hearing. I struggled with how to present these, where to start. Do you start with the default, or do you start with the question of whether or not the Constitution in Tennessee Article 10, Section 1, requires that persons who are authorized to make adjudicatory decisions, not clerical staff, but adjudicatory decisions for the Commissioner of Safety are required as officers for profit and for trust to take an oath of the office to which they are applying. And those officers in this case would be members of the legal division who make adjudicatory decisions, not clerical decisions, adjudicatory decisions for the delegated by the commissioner. Secondly, the persons the commissioner assigns to its appeals division in this case, for which the appeal was to Chancery Court. And third, the administrative judge's decision, who makes decisions in forfeiture cases in Tennessee for the commissioner. Now, if I could go back for just a minute, I'm in a peculiar situation of arguing the case of Monsieur versus the Board of Professional Responsibility. You might note a similarity in the names of those cases. But I have in my brief listed a number of distinguishing facts, but I would like to emphasize several of those. First of all, in Monsieur, the Supreme Court held that members of the Board of Professional Responsibility were not traced back to their origin to any legislative process by the General Assembly. The Commissioner of Safety, his appointment of persons he delegates to are created by the legislature, directly opposite from what the Supreme Court held in Monsieur.
Isn't that true, though, of every government employee that works in a department or agency for the state of Tennessee, that they're a creature of statute created by the legislature? General Assembly's passed some statute, it's created an entity, and that's created by the legislature. And
yes, sir, I would agree with that, but the point of the matter is that the Chancellor in this case relied on Monsieur versus Board of Professional Responsibility. And what I'm suggesting to this court is it's easily distinguishable, because in Monsieur the Supreme Court says no, the board members do not have to be sworn because they were not created or traced back to a legislative creation.
Counsel, there is additional case law in that area beyond the Monsieur case, though. I assume you agree with me on that. And the court has looked at things, for example, like a term of office. Is there a term that's provided for? What kind of stability is created with regard to that position? Is any of that present here? Aren't the administrative judges in this case essentially at-will employees of a government department or agency?
Well, I don't know that. I would think that they might have protections under the Civil Services Law, number one. And number two, the commissioner does not have to take persons' property, which is constitutionally protected by the 5th and 14th Amendment, does not have to use people who are non-sworn to do that. It may come as a shock to many people in this state, and I would hope that this court looks very closely at the fact that our liberty and our property are protected by constitutional privileges. And the people who take those from us, by our Constitution, Article 10, Section 1, are required to take an oath of the office by which they are acting to take a constitutional privilege. Stated another way, we could not fathom a judge who is not sworn, and we know that it would be without jurisdiction to take a person's property when they aren't sworn, because it's a defect in the structural process of our constitutional system of justice. But yet, you are correct.
If the judge doesn't take an oath, is there an absence of subject matter jurisdiction?
I have called it an absence of subject matter jurisdiction. It is actually a lack of jurisdiction. We have cited to the court the Comer versus Ice in several cases, including the Bankston versus State case that says that where an official is, and also the Colonial Pipeline case, that says where a state official is acting in violation of a constitutional provision, then their actions are void and illegal. So if a judge has not taken an oath of office, and if that is raised before that judge or on direct appeal, as it has been in this case, under the Bankston case, then that is void constitutionally, according to the cases that we have cited to you. Now, let me state the second thing. The Supreme Court said that the Board of Professional Responsibility isn't compensated. In other words, they aren't for profit. Administrative judges, appeals designees, and the officers in the legal division that make adjudicatory decisions are paid to do that. They're paid to do that. Thirdly, the Board of Professional Responsibility sits in a adjudicatory process for itself, which is appealable to the Supreme Court. In the case of in the decision-making adjudicatory responsibilities of the legal division that we've outlined, and of the appeals division designee, and of the administrative judge, they're making decisions in lieu of and for the commissioner, which leads me to the point of, are they deputies? Because if they are deputies of the commissioner, the word deputy not being defined, under Tennessee Code Annotated 818.1112, they are required to take the same oath of office as the person who they are acting for. Statute's very clear. So the question becomes, are they deputies? I have found no case in Tennessee that defines deputy. However, Black's Law Dictionary defines deputy as a substitute, a person authorized by an officer to exercise some or all of the functions pertaining to the office in place of and instead of the latter. That's the case with administrative judges, with appeals designees, and with legal division employees.
Counsel, how does the carve-out for individual case assignment apply to that requirement here?
Not real sure. I researched that quite thoroughly. I could not find any explanation for that except some confusing comments that I briefed in this case. But if that carves out everybody that is subject to a general duty to perform the commissioner's duties, then the deputy's oath means nothing. It doesn't mean anything. It negates the whole purpose of taking the commissioner's. Now, in this case, we have submitted the commissioner's oath. Under Red versus the Department of Safety that we have cited throughout our brief, the commissioner is required to make broad powers whether or not to take a person's constitutionally protected property, one of those sacred constitutional privileges that we have.
Counsel, you've cited multiple different statutory constitutional foundations for the idea that there's an oath requirement here. I want to ask you about the one related to, that arises out of Title 17. So you've got the Title 17 reference as a statutory obligation. The every judge and chancellor required to take an oath. Yes. That particular provision. Yes. The language of that statutory provision begins, though, with before entering the duties of office.
That's
so
correct.
What is the office of an administrative judge?
To hear a forfeiture case for the Department of Safety for the Commissioner of Safety. That's the office. For the appeals designee, the commissioner appoints someone to make decisions that the commissioner is required by legislation to make for the commissioner. With regard to the legal division, the statutes provide, and I'll just give you two examples. The statutes provide that, number one, the legal division, upon receipt of the documents from the seizing agency, is required to investigate, that comes out of State versus Springer, and to make a determination whether there is a factual or legal basis that makes that property forfeiture.
Are there any other references in Title 17? And there's one with judicial conduct, right, in terms of Board of Judicial Conduct doesn't apply to administrative judges. Are there any other references in Title 17 that would suggest that Title 17 is aimed at or includes administrative judges?
No, sir.
Okay.
No, sir. For that analogy, I go to the Supreme Court rules that are cited in my paper that says administrative judges or other persons that make adjudicatory decisions are judges within the meaning of the Code of Judicial Conduct. I'm drawing on that.
And the Code of Judicial Conduct doesn't anywhere address, administrative judges included significantly in the Code of Judicial Conduct, but there's nowhere in the code that addresses an oath obligation.
Title 17, you're correct, sir.
Right, or in the Code of Judicial Conduct, right? Is there any reference in the Code of Judicial Conduct?
I believe there is, sir. I believe that
a reference to an oath?
It's 10B1, if I'm not mistaken, that a person who makes, they're cited in my papers, that makes an adjudicatory determination or an administrative judge.
Defines him as a judge, but does it say anything about an oath obligation?
Well, no.
Okay.
No, I'm drawing on that analogy, sir. It does not say, but if they're considered to be a judge, then we know that the code, as well as the Constitution, require that a judge take an oath of office. So, you know, we've got these people who are appointed to hear these forfeiture cases, and I want to limit my argument to forfeiture cases because forfeiture cases have a particular standard under the Red case that we've described and under State versus Sprunger that we have described.
Yes, sir.
Okay, now.
And your time has expired, ready for, you
Yes,
have
sir.
your rebuttal time, though.
Thank you, sir.
Eppley? Will there be one argument or two? Okay, and have you divided your time?
Yes, Your Honor. I'm with Miranda Jones with the Department of Safety and Homeland Security from the Attorney General's office. I'll be taking 10 minutes and then 5 minutes will be reserved for.
Okay, then you may proceed.
Thank you, Your Honor. Your Honor, this case involves a very lengthy administrative procedure record and a trial court record or judicial review record. It's a heavyweight case when it comes to the record, but lightweight when it comes to the legal issues. It's pretty straightforward. The Chancery Court should be affirmed on all 4 grounds, and we have briefed that in our opinion. I am happy to discuss any of them, but since the oath issue seems to be the focus of Your Honors today, I can focus on that as well. There are 4 reasons in petitioner's brief why the petitioner claims that the commissioner's designee and the administrative law judges were required to take an oath of office. Now today, petitioner has argued that potentially several other additional individuals are required to take an oath of office in the legal division and the appeals division before getting to the ALJ. On that point, Your Honors, the only matter that has been discussed in the Chancery Court and that the Chancery Court ruled on was the commissioner's designee and the administrative law judge. And that is significant because those are the only 2 officials who issued orders that were under review in this case. The commissioner's designee issued the final order, which is the order that was reviewed by the Chancery Court and is under review by this court. And the commissioner's designee in that order was reviewing a denial by the administrative law judge of a petition to reconsider a default judgment. So those are the only 2 officials at issue in this case, state employees, if you would. Under the Tennessee Constitution, a person who must take an oath of office if they hold a position of trust or profit. Now, petitioner's definition here today of that term, office of trust or profit, would encompass potentially every employee of the state of Tennessee. He's argued because they are paid, they hold an office of profit. That's something he mentioned today. He mentioned in his reply brief. And, Your Honors, payment is not a sufficient basis for finding an office of trust or profit. That's not what the courts have found in cases dating back to I believe 1917 is the earliest case we cite in our brief. And the same as the use of the word office of trust. The courts have not viewed trust as meaning you are acting in some capacity to carry out state law. That does not make it an office of trust or profit. There are two ways that a person can fill an office of trust or profit. The first is if that person is filling a position created by the Tennessee Constitution. We all agree that's not an issue here today. Commissioners designate administrative law judges, they're not contemplated by the Tennessee Constitution. So that leaves us with the second category, which is if the General Assembly statutorily created a position, but there's quite a bit of specificity that the court in State versus Buck, that 1917 case I mentioned earlier, talks about. The key issue in deciding if it's an office of trust or profit created by the General Assembly is one of discretion. If the General Assembly leaves no discretion to anyone and basically defines the full parameters of the position by setting out the term of office, the amount to be paid, clear specificity as to the duties to be carried out, then that is potentially an office of trust or profit. But if there is discretion given to some supervising entity to hire and fire the person, to decide what their wages are, to designate their specific duties, then it's not an office of trust or profit.
Counsel, there are multiple bases in the Constitution, statutes, rules that opposing counsel's leaning on as origins of the requirement to take an oath here by the administrative judge, by the designee in this case.
Yes, Your Honor.
You've argued in your brief that at least some of those have been waived. Is the failure, if there is an oath obligation, and I know you're saying there's not, but if there is an oath obligation, is a failure to take an oath a matter, does that relate to the subject matter jurisdiction of the court, or is that not a subject matter jurisdiction issue?
I'd like to tease that question out carefully, if I may, Your Honors, because the reason subject matter jurisdiction, I think, was introduced into this case was through an attempt to argue that an oath of office is required under the U.S. Constitution, and we argued that argument was waived, and that's where petitioner argued, well, this goes to subject matter jurisdiction. But the key issue there is subject matter jurisdiction for this court, in order to be able to rule on a waived argument, has to relate to this court's subject matter jurisdiction. And whether or not the commissioner's designee or administrative law judge were required to take an oath of office has nothing to do with this court's jurisdiction to review the commissioner designee's ruling. Now, whether or not it affects their subject matter jurisdiction over their own particular matters that they're reviewing, I'm not sure that subject matter jurisdiction is the exact correct term, since it's not a court, it's an administrative proceeding, and the concept of subject matter jurisdiction is embodied in the existence of a case or controversy or statutorily created jurisdiction embodied or given to the courts. So since it's an administrative proceeding, I'm not sure that the term subject matter jurisdiction would apply at that level, but certainly validity of their rulings would be at issue if they were required to take an oath of office and they had not taken one. But for matters of this court has subject matter jurisdiction to review their rulings. And therefore, this argument that, well, they're required to take an oath of office under the United States Constitution is jurisdictional, that's combining two arguments that don't combine, because whether the United States Constitution required them to take an oath of office will not affect this court's jurisdiction to rule on that issue, so that argument can be waived. And we argue was waived because it was not properly presented to the Chancery Court. And that, if I may return briefly to the Tennessee constitutional issue that I had mentioned earlier, under the Tennessee Constitution, the oath of office requirement, as I said, has to be statutorily created and carefully defined. Here we have supervising entities that are given the authority to hire and fire the commissioner's designee and the administrative law judges. Those entities are respectively the Commissioner of the Department of Safety and the Secretary of State. The statutory parameters for those positions are both left quite vague. Neither of them have terms of office defined. Neither of them have compensation defined, because that's left to the supervising entities. So that key concept of discretion in State versus Buck is present here. Discretion is given to the supervising entities, so the commissioner's designee and the administrative law judges are not filling offices of trust or profit.
Counsel, the Tennessee Supreme Court, with regard to the Code of Judicial Conduct, has included administrative judges within the scope of who's a judge. With regard to Title 17, there's a specific carve-out with regard to the Board of Judicial Conduct for administrative judges. Why shouldn't we read that as the vaguer, when we're thinking about the vaguer language in Title 17 as to a judge, that the legislature is providing for an oath requirement for the judge?
Your Honor, we addressed exactly that point in our brief, and that's because the Code of Judicial Conduct further down clarifies that Title 17 doesn't apply to administrative law judges. We cite the specific provision in our briefing. I believe it's comment number 4 to the section that talks about it.
Is it all Title 17, though, that is disclaimed, or is it just the Board of Judicial Conduct that is disclaimed under the Tennessee, under the Code of Judicial Conduct?
Thank you for correcting me. Yes, it's not the entirety of Title 17, but we think that that is an example of the fact that not every application of the Tennessee Code that applies to a judge is therefore adopted by the Tennessee Supreme Court as applicable to all administrative law judges.
The Title 17 statutory oath requirement, and I asked opposing counsel this question, I want to ask the same question to you. It begins with before entering the duties of office, and I asked opposing counsel, what's the office that an administrative judge has? He points to an assignment of an office for handling the particular subject matter in this case. Why is that, or is that not a correct understanding of the statute?
Because here, Your Honor, administrative law judges, while state officials, don't embody an office in the same concept that a judge embodies an office at the trial level. Judges are entering into office. They are elected or appointed. Administrative law judges are hired. They serve more as employees. So, Your Honor, that portion of language you identified further shows why that statute should not apply to administrative law judges, because they are not entering into an office per se. And the example of them fulfilling specific terms, there are instances where their function is very diverse. They might serve to advise the Board of Claims on whether or not to award a payment to a state employee. The term office, in the sense that applies to a judge, would not be analogous to what an administrative law judge does. So that statutory provision in 17.1.104 simply wouldn't apply to them. And for the reasons in our briefing, nor would the other statutory provision, 8.18.112, or the United States Constitution argument, which is waived. And, Your Honors, I see if there are no further questions, I see I've run out of time, so we ask that you affirm the decision of the Chancery Court on all grounds.
Thank you very much. Yes, sir. No. Yeah, Ms. Munson, right on this side.
Hopefully I'll be brief. Your Honors, I'm Thomas Hickey from the Chattanooga Bar. I represent Bradley County. There was a statement made earlier regarding the duties of an administrative judge, and I think that sort of explains, or the answer sort of explains my limited involvement in this case so far, which is that I believe Mr. Monsieur stated the duties of the judge is to hear cases for the Department of Safety and the Commissioner's designee. I represent a county that the trial court found correctly was not a party to or did not participate in the administrative proceeding. We were not even named in the original petition for judicial review. We were brought in an amended petition for review, and if the court noted, there was a substantial period of time that passed that we were not even included in the litigation. We were not included with certificates of service, didn't participate in the litigation because of our really lack of involvement. So I think my presentation is fairly limited, and I hope that came through in my brief, that the trial court looked at the record on judicial review and said, well, there were no findings whatsoever regarding anything having to do with Bradley County. So how can any claim for attorney's fees regarding bad faith under the statute that is cited in the opinion, it's 40-33-215, or any claim for attorney's fees under a 1983 or 1988 consideration for constitutional violation, how could that be subject to judicial review? There were no findings. That's simply my position, is that there's nothing within the record to support any recovery against Bradley County, and the trial court, the Chancery Court, found that and properly dismissed the case. When I read the arguments in the appellant's brief, I think there were several enumerated, and the one that struck me that was directed to my client was that the trial court, I keep saying trial court, the Chancery Court erred in dismissing the case as to Bradley County with prejudice. Well, the Chancery Court dismissed all of the claims with prejudice. I'm not even sure I understand what that argument is based on. Simply put, I think that because there were no findings against or related to Bradley County, there's just nothing for judicial review, and the Chancery Court and the Chancellor appropriately applied the statute, followed the law as it relates to the actions that could be taken, and then properly dismissed the case as to the county. There was a finding of default. The Chancellor went through all of the elements that she was to apply, properly did so, and did not find an error within the administrative proceedings. So for those reasons, we would just ask that the claims as to Bradley County be sustained, and that the trial court, or the Chancery Court, be affirmed in that respect. The issues regarding the oath and the other matters pertaining to proceedings for the Department of Safety and Homeland Security are better briefed and argued by counsel, and so I would defer to the department on those issues. But for those reasons, Your Honors, we just would request that the trial court's order be affirmed and the case remain dismissed.
Thank you, sir.
Thank you, Your Honors.
Yes, sir, Mr. Marcel.
With regard to Bradley County, the reason that we're here is because the Chancellor did dismiss claims, constitutional claims against Bradley County, because they had not been proven. But as the court knows from another issue that we briefed thoroughly, the Chancellor pre-admitted all of our constitutional claims. So consequently, we were never heard on our constitutional claims. And those constitutional claims, assuming that the court grants relief from the default judgment, would go back to the trial court. But currently, as it stands right now, Mr. Patterson can never pursue any of his claims against Bradley County because they were all dismissed with prejudice. So it's the with prejudice that we were objecting. There was no reason to dismiss them with prejudice. Let me very quickly move to my Sprunger argument, if I could. Thank you, sir. In State versus Sprunger, they went through the cases that I cite, and I've cited several times before members of this panel. And that is the Wells versus McCandless case in 1947, the Red versus Department of Safety case in 1996, and the State versus Sprunger case decided on March the 9th of 2015. And they went through the strict compliance with the black letter of all of the statutes relied on for the forfeiture proceeding. And they held that if the state cannot prove strict compliance with all of those requirements, then there is no confiscation. And that's because of the nature that the law does not favor forfeitures of profit. But I want to read to you in State versus Sprunger, and I've debated this before, a member of this panel before, as to whether this creates a condition precedent, that is, that the department must comply with before the department can go forward. And it says, in light of these principles, we hold that in forfeiture proceedings, the governmental authority seeking forfeiture and must present affirmative proof that it has complied with both the procedural and substantive requirements in the forfeiture statutes enacted by our legislature. Consistent with the civil nature of the forfeiture procedures, the state's burden of proof to both the procedural and substantive statutory requirements by preponderance of the evidence. We repeatedly moved for a Sprunger compliance hearing for them to comply with what we contend is a condition precedent for them to have subject matter jurisdiction to go forward, including a default judgment. Including the default judgment. So consequently, I want the court to understand that not only do we challenge the subject matter jurisdiction of the department and of these people, we also challenge that. Lastly, Henry versus Goins was never ruled on, which is regarding the standard of proof, a standard for the granting of default judgment. Henry versus Goins specifically said, if there is a reasonable doubt as to the justness of the default, then relief must be granted as we sought. I have filed out of the record today the affidavits my office filed with regard to how it occurred that we did not know that there was a hearing on November the 16th. Those affidavits were never analyzed by either the appeal commissioner's designee or by the Chancery Court. And neither the appeals commissioner's designee or the Chancery Court applied the question of whether or not that created a reasonable doubt as to the justice of taking this man's vehicle by default, when my colleague from the Attorney General's office talks about the extensive litigation that we outlined in this case that we had gone through. 27, I believe it were, challenges that we made. We parroted the ruling of Judge Darnell, Stephen Darnell, that had just preceded this case as to how the department was not following its own statutes, as it was not following the Administrative Procedures Act. And the last thing, and thank you for not cutting me off.
Well, I'm about to.
I know you are. I can feel it. I can feel it coming across the bed.
It's time. Your time is up. Thank you very much, sir.
I don't want to hear that last part.
No, your time is up.
We'll move on. Good day. Might be the last time I get to appear before this court, but it's been a pleasure.
Well, thank you, sir. I want to thank both parties for your presentation. Your case has now been submitted to this court for resolution. At this time, the parties may be excused. And Madam Clerk, will you recess court till tomorrow morning?